What's up, everybody? And we're back here talking about the Koberger case and trial, specifically about the Kings Road house and the demolition that seems to be happening, underway, about to happen, something that's going to take place in the near future before the school year starts. And I've had a lot of questions about why would they do this? What are they balancing? What do the victims think about this? So today we are going to watch an interview with the Gonsalves family attorney, Shannon Gray, about that demolition with Brian Enton. And it's kind of multiple things we're going to discuss, whether or not we think he's violating the gag order, but also his thoughts on it, the victim's thoughts on it, why it's happening, and whether or not we agree. What are our thoughts? And let me know your thoughts in the comments here before we watch the interview and before you get my thoughts. Let me know whether or not you think this house should be demolished on Kings Road with its connection to an active criminal case. Hit that like button if you haven't already, if you are still interested in this Koberger case, and subscribe to our channel. As we just crossed a big threshold, really fun, but let's, keep grinding and moving and growing towards the next one. So I appreciate it. Everybody that's joined the community here. It's a lot of fun. We're going to be posting more polls. We still haven't settled on what we're going to do for the 250K celebration. So we're looking forward to more interesting and fun stuff as we continue our educational pursuit here on the channel. So demolishing the crime scene in a case like this, what does the court balance? What does the parties balance? Why would they ever do this? Well, it does cost money and resources and space to keep a crime scene active and to keep it in place in the way that is most similar to when the crime was actually committed, right? In the same or substantially same condition. So I can understand why public entities would want to knock it down, demolish it, repurpose it, and not have to continue keeping it open. It's obviously tax dollars, the people that live there. So all of that is kind of on one side. And on the other side is, what if? What if this becomes an issue in the future? What if there's a new claim that we need to cut into the floorboards or cut into the wall or see if there was spyware somewhere, or somebody makes that claim that can't be refuted at this point once it's demolished? What if some new evidence comes to where we have to go see how the house was built or who built the house or what they did? I mean, we can still find out who built the house, but you get my point. What if something comes up in the future that could have been answered if the house would have still been in the same or substantially same condition as when the crime was committed? That will no longer be able to happen. That testing will no longer be able to happen. So how do we combat that legally? Well, we allow both sides to enter, to test, to examine, to have experts examine and test every inch that they could possibly want to. And now this case is, 8 months-ish old. They've had plenty of time, both sides, including the victims, actually, and the victim's family, if they wanted to hire experts to go in there, because there could be civil cases, like we said. They could have hired experts to go in there, look at it. I'm sure the judge would have allowed it in the criminal case, because if it's going to be gone, then this is the only, in the interest of justice, this is the only way they can preserve whatever their experts are going to say that, think about it. If you're going to sue the police because they screwed up, if you're going to say the police didn't do something or they missed something, well, you have to prove that. You have the burden to prove that in the civil courts. So how would you prove that they missed something at the crime scene if the crime scene's gone? Well, you send an expert in there and they figure it out. Obviously, if you do that, you're probably going to put them on notice so that they can go and use it against the defendant in the case. But there are all sorts of moving parts here because of the criminal justice system and litigation that's going on and this potential civil litigation. We know they filed those notices of claim. And by filing those, they protect certain rights. And it would give them the ability, I believe, to go in there and do testing and do examination on the crime scene. So that's kind of what the court is balancing here. But it also kind of seems like the court didn't have much to balance, because it seems like the state and the defense have agreed to demolish the house. There's a lot being reported, a lot we still might not know, but we are going to hear from the victim's attorney here on where they stand. And I think it's important to keep in mind other cases where we've seen the evidence preserved, the crime scene preserved, or a big piece of the crime scene, like in Darrell Brooks, they preserved the car. In the Melly trial, they preserved the car. Preserving a car is a heck of a lot easier and cheaper than preserving a house. But you know what's a lot more difficult and a lot more expensive than preserving a house? Preserving an incredibly large school. 73 yards, football fields, all these different buildings and different parking lots that we heard about during the Scott Peterson trial and the Nicholas Cruz trial. And there are a bunch of civil lawsuits going on there or that have taken place there as well. And if you ask me, there's also part of the balancing considerations for a judge if the judge would have had to make this call. I think the judge would say to keep it if there was a fight, my honest opinion. But also the way it affects a community, the healing that maybe can't take place until something is demolished. And you think about every time you drive by the Kings Roadhouse or just knowing it's there for the Idaho students is probably very difficult. But again, even more so, the Marjorie Stoneman Douglas School in Parkland. I mean, how horrible. I mean, generationally, people are connected to that school. Family members or students, teachers, coaches, resource officers, whatever. So many connections to that community. So difficult, yet they left it in the same or substantially same condition. Mark Eiglar's talked about potentially a jury view because it was still available. And when he saw it, how horrible it was and how you could still see gory details of that horrific day. And it took a lot of taxpayer dollars to keep that in substantially similar condition to what it was the day of the crime. So this is not an outlier. It's not something that never happens. It happens very often that we have to preserve these crime scenes. I'd be interested to know why there wasn't more of a push to preserve. And they almost started doing stuff to it way earlier, if you remember. And I think the defense objected and stopped it so they could do some more testing. But I always think it's interesting to hear from the victims because in these cases, the state attorney does not represent you. And as long as what you want aligns with what they want, it seems great and everybody's on the same page. But as soon as it doesn't, they do what they want to do. They represent the state. They don't represent the victims. So let's take a listen to Shannon Gray. And again, let's keep in the back of our mind the gag order. He can't say a lot of things. He can't reveal anything confidential about the case. He can't talk about guilt or innocence. He can't talk about certain witnesses or parties or their backgrounds or whether it's good evidence or bad evidence. He can't talk about a lot of stuff like that. So let's take a listen to what he does say.
I mean, what's the deal in Moscow? Why has this become such a big deal?
I really can't explain it to you. It seems very commonsensical. What a privilege it is to the University of Idaho to be able to just demo the place and move on. That's not something the victims' families or even the community has the opportunity to do. But
so he's flipping part of the balancing act on its head. It's about healing. It's about the community. Well, it must be nice for the University of Idaho and their students and their faculty and the parents of the other students to be able to move on if they demolish this house, because that's not something the actual victims, I may have said the victims' parents, I meant the students' parents. The victim's family cannot just move on if they demolish the house. And it could negatively affect the victims' families in criminal court and civil court, yet that doesn't seem to matter. So he flips part of the balancing act of the community healing on its head, where who are we looking out for? People that just don't want to see it and be bothered by knowing what happened there, or the people whose lives were actually changed forever?
But they've taken this stance where we want to know what you think, but then we don't really want to listen to what you think if it doesn't agree with our line of what we want to do with the house. So,
and now he's talking about the University of Idaho. They acted like they want the victim's opinion. When we give them their opinion, they still do what they want to do because it's their house.
It's beyond me and it's beyond the families, the Gonzalez family in particular, about why they're demoing the house, why they're moving so fast. I think we've expressed, over and over again to them that it's important to just keep the house there just in case someone needs it. And then when the trial's over, do whatever you want with it.
I 100% agree with him. I don't know what they've done as far as trying to get a court order to preserve it. I have not really been in the loop on that, but I would have done everything I could to keep this house up and in place and in some kind of similar position it was in the night the crime was committed. So I agree with him 100%. I don't get why. Why move so fast? Why not just preserve it until the trial's over, until we know there's no issues? We know that there's not going to be something that pops up where we say, man, we wish the house was still there for us to test or see something or measure something. Why do that? Now, they can take certain scans, 3D scans, and we've seen that and how you can walk through the house and everything's measured. So you can do a lot with technology today. But even on the slight chance, it becomes important, especially if you think, like as we sit right now, nobody on this channel believes, not nobody, it's very low likelihood that they try this case in October. But right now, it's set for October. So we're all pretending the trial is going to happen in October and hoping, I should say, not pretending, hoping the trial is going to happen in October. We can't wait 3 more months. How expensive is it to keep a house for 3 more months in the same condition it's in right now? You don't have to mow the lawn. You don't have to do anything like that. Don't even, turn on the AC or the electric, whatever, no water. How expensive is it for just 3 months? We're not talking 5 years here.
And the response has basically been, victims' families spend legal money to give us a legal argument on why we shouldn't have to be able to demo the house.
Okay, so maybe they did say, take it to court, file a motion, and the victims are like, so now we got to spend money to not demolish the house? By the way, I would think if you just file the document, try to get a court date, it's going to take a month or 2, right? So that's just one way to delay it, but interesting. I'm surprised they don't want to file something. They filed motions and made arguments about the non-dissemination order,
which I find is just absolutely ridiculous.
Yeah, it's interesting that they asked the families what they thought, and even hearing from most of the families that they didn't want the house to be demolished, they're still going forward with it anyway.
That is so common. I represent a lot of victims in situations where, either the criminal process is going with the prosecutor or there's some other entity like a university or a business who acts like they care and they want to do what's best for the victims and their families. They want their input and they want them to be part of the process. But in reality, they want the victims to be okay with what they want to do. They're looking for the affirmation. We really want the victims to be on board. Yeah, on board with what we want to do, not what the victims want to do. That's most of the time how that interaction goes.
Prosecutors do anything? I mean, obviously the families are in close contact with the prosecution. Can they not step in and say, hey, can you guys just, wait 6 months or so?
Well, I think that's part of the non-dissemination order, right? I'm an attorney that's involved. I can't comment on what I think the prosecutor should do,
So can you just ask the prosecutor? Well, I can't comment on that, which to me sounds like the parties, prosecution and the defense, don't care to block the demolition. Almost seems like they agree. Go ahead and demolish it. Because if he's telling us he wants it blocked, he wants it stopped. And that's what he told Idaho, the University of Idaho. Why would we not then also think that's what he told the prosecutor? He's like, I'm not going to say what we told the prosecutor, what we think they should do. I think we know.
I think the defense should do any of those things, right? So I think the Gonzalez family and it seems that the prosecution and the defense have both released the house. And I think everyone can make their own opinion on that, but I can't comment on it because of the non-dissemination order.
I understand. So, one of the things,
and again, they released the house because they were able to do their testing. Their experts have already been there. Maybe they've done the 3D scanning and things like that. They feel like they've done everything they need to do. And maybe they're feeling pressure from the community, from the University of Idaho, that they want to demolish this house. What's up, everybody? You probably know that there are a ton of body hair trimmers on the market right now. So when Manscaped sent me the Lawnmower 4.0, my first question was, what makes this different? And then I used it. And there are some major upgrades I did not know about. First, it is fully waterproof, so you can use it in the shower or clean it immediately after use, because we all know how disgusting some of these body hair trimmers can get, all clogged up with hair. Second, there is a light on the razor, which is great for trying to reach hard to see areas, and also great because if I want to buzz early in the morning or late at night, I don't even have to turn the light on and wake up my wife, because there is a light on the razor itself. And lastly, the size. It is the perfect size. And get your mind out of the gutter. I'm talking about the razor. It's not too big or bulky to travel with or to leave on your counter charging wirelessly, I may add, but it's also not too small and dinky and easy to drop when you may be buzzing a delicate area. They also have a brand new beard trimmer I haven't used yet, but I am very interested in. So either of these products or anything on their site, if you're interested, you can use my promo code LAW20, LAW20 for 20% off anything site-wide on manscape.com. So check it out and let me know what you buy and how you like it.
It's been hard to track, Shannon, is the timeline on the demolition, because they said it was going to happen imminently at one point, which was quite some time ago, and now they're still removing items from the house, but it is still standing. Are they giving the families or you any more specifics on a timeline?
No, not really. I mean, initially it was set to be demolished, and then the defense put a stop to it. And then they got a chance to go in and take a look at the house, things like that. And then the private items, the personal items were removed. A lot of the personal items were removed from the home. They were turned over to the families. And then they contacted us and said, hey, if there's any kind of furniture or large items that you might want that are still in the house. And I was contacted by the families and said, hey, Shannon, can you walk the house so we can see if what we want and what we don't want? And basically the university said, no, Mr. Gray, you're not going to be allowed into the house at all.
See, I have a problem with that. I think he should be allowed to be in the house. And again, I do think he has some legal tools potentially with that civil notice of claim that he filed to say either block it because we may have experts that want to go in the house, or I want to go in the house because I want to go look at it to see if there's any evidence of any wrongdoing by the University of Idaho. We might sue them. By the police, we might sue them. That's what a notice of claim is. So I get we all want to play nice, but we might sue the prosecutor. We might sue the police. We might sue campus police. We might sue the university. We might sue any of these sovereign bodies. So we want to go look at the house, and we want to be entitled to look at the house. Did they cover it up? How would we be able to? First off, I'm not saying any of that happened, but I'm just saying if you really want to get into a house, you've got legal leverage and tools. Like if the cops covered something up, if they set up Bryan Kohberger, if they planted something, we're not going to know that unless we go in the house. You should be able to go in the house as the victim's attorney, as the victim's agents or experts.
And we'll remove the items, and then we'll let you know when you can pick those things up or get those things. And so
you can definitely file a motion for entry on property in civil cases, or even as a victim in a criminal case, you can at least try it and see what the court says. I haven't seen anything like that. It may have been filed. I haven't seen anything like that.
So, and throughout that entire time, from the beginning, we've asked them not to demo the house. So it's been going on for months of asking them.
So I think we know what he told the prosecutors, or what the victims told the prosecutors.
And every time they come back and they give us a date, it gets moved back. So I'm hoping that they'll just stop it.
Well, we saw in Parkland, and granted, it's a different situation. More time has gone by in there, but I mean, to see that some of these families are going to go inside that building, it breaks your heart. But at the same time, you can understand, people want to see where their loved one, had their final moments. Is that a discussion that's come up at all with the Gonzalez's or any of the other families that in terms? I mean, would they eventually want to go inside?
Well, remember in Parkland, though, they know who did it.
Yeah.
They knew who the person was. I think he admitted to it. They arrested him on the scene. And the jury still wanted to go take a look at the property, right?
Yeah.
This is a case where we don't know anything about the case. We don't have any facts about it. We don't know what's involved in it. And so I think it's emotional for a lot of the families as well. It's the last place where their child was. And I think as part of the healing process as well, is you may not want to step in that house now, but maybe later you might.
Yeah, and so it takes jury view completely out of the question during the trial, right? We're not even going to have the discussion. I mean, we've seen jury views in Murdoch. We've seen it in Parkland. We might see it in Melly. We saw it in Darrell Brooks. I mean, it's not uncommon that the jury might want to view something, especially if it's readily available, and it may be really important where the sliding glass door is to help them get a better picture of spatial awareness. If you're Bryan Kohberger and you say, I would have had to go second floor, third floor, do this, that, and the other in only 12 minutes, or whatever it is, it's like that might be something that could be aided by a jury view if you're making that argument as the defendant. Or if you're the state where you're saying it sounds like it's not a lot of time, but let's go walk the property. And when you walk it, think about how long 12 minutes is and how long it takes you to walk up to the third floor and second, whatever. Either side could use that argument. Either side could potentially use a jury view in cases like this. But now that even strategy or that thought is completely taken away. And I guess the reason is like, why? It's not like toxic waste is oozing from this house and people are in danger if we keep it up. It's more like it makes us feel bad, so we want to get rid of it. And to me, if I'm balancing a fair trial versus, somebody doesn't feel good every time they have to drive by that house, by the way, demolishing the house is not going to stop that people drive by the location that it happened. It can be a plot of grassy land, and people that know that that's where the Kings Road house is, when they drive by it, they're still going to know, especially the victim's friends and family.
I want to take a look and just be where your child was the last time they were alive. And it seems very dramatic, but it's a very emotional. And you also, the families, there's a need to stay connected to the people that were there, Dylan and Bethany, as being their roommates. I think the families feel there's a certain amount of bond there because they were there, right? And you can't explain it as the victims' families. Only the victims can go through that, or are going through that. But there's a lot of value to it. I think there's a lot of evidentiary value to it, and then there's also the personal aspect of it for the families. And I
really couldn't be more in line with him on this issue. I think he's 100% correct. I think from a victim standpoint, he is explaining it exactly what would benefit the victims most, and what are we balancing it against? That's the point. Like if we were balancing it against, keeping the house up makes it impossible for Bryan Kohberger to get a fair trial, then I think we can have a conversation. If we're balancing it against other people are getting hurt, or again, like I said, it's oozing toxic waste, then I think we got to talk about it and get rid of it potentially, because we don't want other people to get hurt just for these balancing issues. But balancing it against what we have here in this case, I'm in line with him completely on this issue.
Implore that anybody who has any influence on the University of Idaho, who's a graduate, or calls them and tells them to stop what they're doing and listen to the victims' families.
Yeah.
And there you go. Using media for positive change, right? And that's part of the reason he got in the case. Part of the reason we started talking about the case is how a lawyer can actually help in the media with victims and their families. He's providing a call to action here on, if you have any connections, if you're a graduate, tell them to stop. Tell them to preserve this. Tell them this is not right. Because it seems to be in their hands because they own the house, the University of Idaho.
It's a really, really good point you make, Shannon. And it does seem like it's just so soon that they just sort of want to erase, in a sense, what happened there, almost from like a PR perspective.
Thank you for watching.
That is a lot of what it feels like, right? I mean, that really is the type of vibe I'm getting to, and because I don't really see what it solves. But let me know if I'm missing something. Is there a better reason to demolish the house? And kind of where do you stand? And what do you think about Shannon Gray's comments? And also let me know in the comments if you think anything he said violated the gag order. Put it in quotes. He said this, and here's the paragraph that it violates the gag order, because I'd be interested to see what you guys think from your perspective on what he should be able to say and shouldn't be able to say publicly. So that's all we've got. Thank you for everybody that sent me this video over the last few hours on Twitter. We've also joined the Threads game, so you can find us there at Tragos Law as well. I'm not really sure how to use it right now. It just seems like Twitter 2.0, I guess. I don't really know. So let me know what you guys think of that. Let me know in the comments if you gave us a follow on Threads as well. We may start using it as a form of communication with some of you. So give us a follow on Instagram and Threads. But that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast, featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.